So thank you for joining us, and we look forward to engaging an insightful session today. And this topic is very, very interesting, and this is connected to all companies, big, small, or uh, any type of structure they are having. Now, what is happening? All corporates house have number of legal entities under their umbrella for various purposes. If you see the old regime, when the license Raj was there, when everything was controlled, so everything you have to think small. You have to think in a different way. That particular time, people were making a small business. So a small business require multiple entity, and they were doing this. But after some time, when liberalization has taken place and everything becoming open, suddenly there was a sea change of small to big. So the need of consolidation is started. That's why India has started everything in a different way. You remember when you have a telephone connection is in also you are getting in 4 years, 5 years. You are getting gas cylinder in a 2 years waiting period. Cars were only very limited. There was a rationing on each and everything. You can't do big. There was a company called the regulator called MRTPTC that is monopoly and restrictive. So the word itself is monopoly mean you become little bit bigger and they will put restriction on this. So the sea change has taken place. Now everything is open. You have to become big. You have to compete the entire world, and then you have to see something differently. So now this changing regulatory environment, changing corporate environment, it's now promoters when they were forming various companies for various purposes, now they are consolidating. But this consolidation process is so cumbersome because when you want to do some business, you require an entity, you just go and do and form the company. If you see real estate companies, they are having 200, 300, 500, 600 companies because Land Ceiling Act was there and there was a restriction. Its restriction is still there at some place, so many places. So they formed company. Then there was a joint venture. For that, you are forming company. So that was the need that time, but now people are realizing that this particular thing I have to merge. When you are merging, then the company is either is going out, or if you are restructuring and then multiple companies business you are shifting, so the entities are becoming open, and when the joint venture is over, when the work is completed, then company is with you, and that is creating a problem. So simple and lean group structure is always is a common now, and implementing and consolidation and simplification has many challenges. Cost of compliances, regulatory permissions, and long-term implications are there. So whenever this word looks good, but when you go for implementation, there is an outflow of the cash also. So that's why people hold on. And because of holding on, there are other problems accumulated. So today in this webinar, we will cover the critical aspects such as why corporate house created so many entities, why it's important for consolidation, simplify the group structure at present scenario. It also deliberate how to approach the leaning out process, including various legal, procedural, and technical aspects of leaning out to meet group consolidation. So today we will discuss understanding the creation of multiple entities, why consolidation simplify group structure, benefit of lean group structure, challenges in consolidation process, approaching the leaning out process, step-by-step guide that we'll do. And today we have one of the expert in our in-house, Mr. Manoj Kumar. He's a partner in head M&A and investment banking. And Manoj has a credit to do more than 500 to 600 corporate restructuring, merger, demerger, amalgamation, selling of the selling of business, slum sale, and whatnot. And this include more than 200 listed company, because listed companies merger, demerger is always complicated and it is just for regulatory scrutiny also. So Manoj has wide knowledge of legal aspects, tax aspects, and stamp duty aspects, and various other things. So this is our plan for today. Manoj will discuss this. But before Manoj discussing this particular topic, I just want to tell you the basic point to everybody, because I'm always advocating the uh, leaning out is a good, or consolidation is good, and it should the need of the hour. Companies, they are having multiple companies, so sometimes they think what is the loss in this if we are doing this. So I want to just showcase you some importance of leaning out of group companies. Then I will tell you some disadvantage, and I will tell you what investor thinks when you have a multiple companies. So first one is the importance of leaning out of group structure. Why simplification group structure is necessary? Because it simplify, reduce operational complexity, compliance costs, and legal risk. Second, it align the group with the regulatory requirement and enhance transparency, because if you have a multiple structure, if you see all frauds which has taken place, there was a wave of companies, and the regulator is always identified and taking a negative view when you do this type of structure. That's why they brought out a two-layer or one-layer restriction in the Companies Act. And because of this, because today multiple structure is required, but complex structure is not required. It's required the regulators different lens. Leaning structure make decision making process faster and resource allocation more efficient, because you have everything in a very simplified process. So this is one part. Now, what benefit does lean group structure provide? If you have a lean group structure, cost saving will be there, reduction of administrative and compliance costs. Now you have a 10 company, 20 companies, and when you are talking to your auditor, you are talking to your account team, you are talking to HR team, anybody. So always they say, sir, मेरे पास तो 20 companies है, मेरे पास तो 30 companies का काम है. Out of the 30 companies, only 5 or 3 companies are active. Remaining companies are inactive and they require, but their work and their compliance cost is always enhanced. Then enhance governance, simplify reporting and ensure accountability. That is another point, because governance process and the simplified process is there. Regulator is seeing, asking information you are giving. So they are also feeling that this company is good. Valuation improvement is also because investor value simplified and transparent structure higher than this complex structure. And every complex structure, you are diluting your value. Then strategic flexibility, streamline focus on profitability and core business area, because otherwise what is happening? It's a top management's responsibility that every time people are, the team is coming and asking, sir, this is the tax issue, this is compliance issue. So it is eating away your maximum strategic time. Now, how does it align with regulatory and strategy object? Align with the regulatory mandate for better transparency, because SEBI and Companies Act says about this, and they are putting all restriction on this type of multiple layer. More investor expectation, because they see compliance should be there. So investor is also feeling happy. Then strategic preparation, because business for M&A opportunity or fundraising is also easy. That is why importance of leaning out is good. Now, this is the good part. But tell me, if you ask me, what is the disadvantage of having this type of multiple companies in the group? So disadvantage is financial burden caused by redundant entities. Now, the company which is not usable but it's lying, so you have to fill every year the compliance responsibility is there, auditor is required, and various other things is there. You require audit, tax filing, and regulatory reporting. All these things, it require costs. Then maintaining dormant companies add unnecessary overhead on return on investment. That is another aspect. Now, increase compliance. When you have a multiple companies, the compliance is increased, and in this process, you will miss out some compliance also. That is also possible. Now, governance and transparency challenge is also there. Multiple entities, you have missed out some compliance. And when you are missed out compliance, the violation is there, and it is creating a negativity. And then investor finds hard to assess the group's health. Now, if I have a company 1 and 2, so you can see this is my main company, this is my subsidiary company. So you can club both the account and then see. If I have a multiple, then you reduce this, you do this. If this company has 30%, this company has 60%, this company has this percentage of equity. So you can't identify the real value. Then operational inefficiency and duplication of resources. Same time you are doing work and redundant work, unnecessary asset infrastructure wasting is there, and you are not taking advantage. Then overlapping various decision making is also there. Secondly, tax inefficiency and risk of tax leakage. Now, cross-entity transaction may attract double taxation or transfer pricing issue. Inefficient tax structure increase overall tax burden, because now you can't give loan to the group companies, which is restricted by the various law, and you have to fulfill some compliances. So sometimes you do this type of mistakes, and some type of somewhere you are giving tax, and somewhere you are losing tax advantage. So this is happening because you can't focus on everything at one go. Reputational risk due to dormant entity. Sometimes investors see that you have a dormant companies. So when you are not able to do this, manage this, then how you will do this, that is another aspect. Reduce marketability in merger and acquisition. Sometimes what is happening, consolidation always good. Buyer, when they say you are going to some company that let's do strategic tie-up, and then tie-up can take place. But when they see there are so many companies, like one example I'll give you, whenever you are bringing out any IPO or any issue, an investor is seeing that you have two companies in the group, same type of work, which is getting fund, and another group company is also doing same type of work. So the question comes, what people think about this? They think that tomorrow you may shift, you are getting an order, you may not transfer here where the investor's money is there, you may transfer to your personal companies where you have a maximum stake. So that fear is also there. And valuation loss is always there, because when you create a structure, when you create a multiple company, valuation is always affected. So this is losses. Now, now another question is, when I say valuation, so how the valuation is impacted? Now, one is how the redundant company dilute companies group's valuation. Redundant company increase costs without contributing to revenue. So this is one cost, and lowering ROI and profitability. So if you have 100 rupees profit and two companies which has 5 rupees, 3 rupees losses, so this 8 rupees will club there, and it will be reduce your ROI, because if you merge this, then you can take advantage. Cross-holding and intercompany debt reduce, and clarity on financial performance is also there. Why do investors apply discount for complex structure? That is another question, because when I say how the investor see how the valuation is less, complexity raises concern about governance, compliance risk, and hidden liabilities, because sometimes you don't know what is hidden in the company, what liability can come. So that's why always they give a discount. Lack of transparency makes the due diligence time consuming and expensive. Whenever you are doing any transaction, anything, then in place of the clean structure, you have a multiple structure, and that create due diligence challenges. Now, challenges in financial metrics like ROE and EPS. Dormant entities always have a liability which dilute the financial metrics, reducing attraction to the investor. Lower EPS and ROE is also reduced. How do cross-holding and intercorporate loans affect valuation? That another question normally people are asking. See, I have a multiple companies, so how can valuation will go down? Cross-holding create artificial inflation of assets and revenue, and intercompany loans raises doubt about the fund diversion or mismanagement, because companies, when they have this company has a fund in this company has a loan in this company, so they think that this company is not clean, they must be doing some hanky-panky. So that's why the always valuation is lost. Now, this is overall. But if I'm an investor, or if you are an investor and you have to invest in the company where the multiple companies are there, how you will see, that is another aspect. So how do investors perceive that group company with numerous entities? That is one challenge. So investor always prefer leaning structure where easy to understand and easy to read and which is transparent. They view always complex structure as a risky and inefficient. Then what investor look for terms of governance and transparency when you have a complex? So they want normally investor wants clear financial result reporting, well-defined accountability, well-defined liability, and robust compliance system. But in the multiple structure, you have a challenge of this. Simplicity in ownership and operational structure, that is also required. You have a one company that holding another company is holding this. So you have no clarity on this, that how much stake you have, how much things you have created a liability on the company. So that's why always investor see is negatively. Now another question comes, why do complex structure deter investor? Because why investors will not come? What is the problem? Because they say compliance risk is there, you may miss out something. They say potential tax liability can also come. They say opaque governance always discourage investor. Then complex structure often delay M&A and funding process because due diligence process and then structure, another thing will always affect. Now the question comes, so what if the investors see all these things? But no, in the reality, when they do valuation, their valuation discounts are associated with complexity. Discount of 10 to 20% are always applied due to risk with hidden liabilities and inefficiency and governance challenges. So if you have a value of some companies 100 and 10 to 20% you will lose because you have a complex system and there is a doubt in the system. So another question is, do you think that investors, does this simplicity enhance the investor confidence? Answer is yes, because linear structure reflect operational efficiency and everybody realize that management is focusing their maximum time on operational. Now, if you see, if I now next come to the real life example of multiple companies. Financial data on compliance and administrative cost. A medium-sized dormant company incur 3 to 5 lakh annually in compliance costs. For a group with 20 redundant companies, the annual cost can exceed to 1 crore. Then some other hidden liabilities can also come. Now, if you see Satyam scandal, and if you see demonstrated a valuation loss, in 2009, Satyam scandal has taken place. They have overstated revenue and liability across entities led to 14,162 crore rupees market cap loss. You can realize because on the surface, it is looking good, but when you see inside, and that's why because of Satyam, 2013 law bring out the 1 layer or 2 layer restriction on the companies. Then regulatory scrutiny. MCA struck 4.6 lakh dormant company in India in 2023. And because it was increasing scrutiny and complex structure, and other than this, they started. Then Mahindra Group, if you see success story of this simplification, Mahindra Group has 100 plus entities and they reduced 40, and that is they must have saved 200 crore annually and boost investor confidence that way when the restructure is taking place. Now, question is how to do this. What types of knowledge you require? You require legal knowledge, companies law, SEBI law, FEMA, tax law. You require financial knowledge, valuation, tax planning, cost analysis, strategic knowledge, risk management, and business restructuring, then operational compliance, filing, and project management. These are the knowledge you require when you do leaning out. But do you think leaning out is easy? No, challenges are there, but solution is also there. Regulatory hurdles are there. So you can do conduct audit, pre-plan compliance requirement you can do. Tax implication is also there. So structure merger to optimize tax outcome, stakeholder assistance. So you clearly communicate benefit and involve them in the planning. Then governance risk, simplify oversight mechanism, enforce internal control. So these challenges can be sorted out if you do leaning out. Some tax and compliances consideration is also required. Tax implication, plan for GST, capital gain, and MAT. Uh, Regulatory filing is also required. MCA, SEBI, and IT compliance. Resolving intercompany liability, prevent tax leakage and hidden liability. So these are the tax compliances consideration you have to do. Then come to the legal and procedural aspects. Filing you have to do, address the cross-holding you have to manage, resolving pending litigation, ensuring compliances, and then you have to see the stamp duty issues also when you do this type of restructuring, and stamp duty is outflow is immediate. Then operational and strategic benefit, efficiency will also take place, eliminate redundancy in the improper and improve focus of the management. Cost save will also be there. Strategic growth will also take place, which align your core business goal. So in a way, if you do this, you will face challenges, but challenges has a solution. And the professional, those who working out on this area, like Manoj will explain to us that if I am doing things, how to do. So these are the advantages which any company can take if they do this type of leaning out. And I have told you the biggest challenge in leaning out, that if you have a biggest advantage of leaning out is if you have a multiple structure, the regulator, the investor, and the P fund or anybody who is coming in, they don't see properly. They see always they have a doubt, and they always give discount. So something which is costing me, which is not giving any result, which is giving me the valuation loss, which is creating a doubt in the eyes of regulator, why we should do this. So that's why we must follow leaning out, and we must consolidate our group, and that is the need of the hour, and that is a business compliance or business strategical business need of this hour. We should do this. We are finding various companies which has a still today 100, 200, 500 companies, 30 company, 20 company, 10 companies, and there's no sense of doing this. Yes, no doubt, first year, first time the cost will be there, but you have to see when you are doing this, you ask your consultant, if I'm doing this, how much I'm saving. So long-term return is also there. And the most important thing, sometimes you keep the company that whenever I require, it may come. So friend, today company formation is becoming so easy, structure becoming so easy. You can form anytime in any place. Keep it one company with you, which is not remaining company you can reduce. So this way we can do wonders in this. So friends, this is my opening comment because it's a very interesting topic, and always I advocate this particular aspect that companies should follow, and they must do something and do consolidation. And today, Manoj will take you the complete journey, how to do this and why this is happening, and what is his practical experience which he has done. And when I pose so many questions, the question is Manoj has to answer that yes, how I can do leading out. So he's a doctor of consolidation. He can tell the consolidated view. And Manoj, I'll request you to give your presentation and give the answer also of. So friends, you have any questions, anything related to anything on the consolidation, whether it's a listed company, unlisted company, whether issue related to company law, SEBI law, valuation, and the other aspects, please write to us. We will just give you answer. Friends, before closing, I just want to announce that on 24th January, we have our next webinar on Friday, 4 to 6. We will meet and we'll talk nitty-gritty on principle B6 and BRSR report. So that point principle we'll discuss. And till then, I will request Manoj, today you just tell us about this leading out concept.
Thank you, sir. Good afternoon, friends. It's one of the most interesting topic, as sir was telling, and sir has given a very wide, detailed description of the need and why companies groups should have simple structure, less number of companies. So, without going in detail on those aspect and necessity, I'm just directly issuing starting my presentation. Hope it is visible. Yeah. So. I think Sir has already discussed in detail why it is necessary to have simple structure, lesser number of entities within the group. So we have seen many of the corporate houses, old corporate houses have to have large number of legal entities. Some are private companies, some are public companies. There are many investment companies within the group also. And over a period of time, there has been fund movement from one company to another as per the need and availability of fund, which has created cross holdings, complicated group of structures, uh, which are consuming a lot of internal resources, cost, and also creating a lot of difficulty in management, determination of which is the right, which person is controlling the entity, and how much percentage holding the person has. So all these things are creating a lot of problem for such groups. So many of the group have already started or done their simplification of group or consolidation of the group entities. And we have also handled many such cases over a period of last 20 years, where we have consolidated 30, more than 20 companies together. In some cases, 3, 4 companies were also collapsed together to bring the holding directly in the hands of the owner or main founder or promoter of the group. It involved, we have seen this kind of structuring happening in many of the listed groups also, and in many of the closely held groups also, where recently we have seen that many of the companies are now planning for going to public through IPO. So all such groups which are now planning to go for IPO are trying to consolidate their redundant companies or non-functional companies, or cross holdings are getting cancelled, so that the structure is clear. The ownership of the shares of the company is directly in the hands of the promoters of the company, and it also helps to represent the case before the regulators like SEBI or stock exchanges. They easily determine who should be considered to be the promoter of the company, who should be considered the promoter group of persons. And if the number of entities are lesser, then it is simpler and easier to identify the control structure, and also carry the diligence process and give the disclosures, which is also very cumbersome in case there are multiple companies within the group. So a few basic regions which is well known to everyone. Uh, Purpose of leaning out is to simplify and rationalize the group structure, to reduce the cross-holding amongst the companies, simplify the control structure for ease of regulatory disclosure. Like we all know that there is a requirement of ultimate beneficial owner disclosure in case of foreign entity, and also SBO disclosures have come under the new Companies Act. So these disclosures required clarity in the structure and simplification of the structure. Then to reduce multiplicity of administrative responsibility, legal and regulatory compliances to be reduced and simplified. Then elimination of extra entity with no operational business, and harness the assets and monetize the blocked assets, money and the funds blocked in those entities which are not carrying any major business activity, is also one of the object. Then it also helps to take advantage of assets and net worth of all such companies which are non-functional, can be consolidated into those companies which are functional, which need funds. Unutilized funds can be easily consolidated at that place. Then to minimize the administrative and managerial cost is one of the key criteria or key reason for simplification and consolidation of group. Then it also heavily reduces the compliance cost. And we all know that the cost of non-compliance is exceedingly increasing. Now, even a small compounding of company law matter can be very costly. So having multiple layer of company and missing certain compliances would be a great loss, financial loss to the group. And also it may have impact on reputation or in future fundraising activity like IPO. Uh, then law itself says that there cannot be more than two layers of subsidiaries which are non-operating in nature. So that also mandates simplification of the group structure. So if we think of consolidation of the group companies, elimination of unused or redundant company within the group, there are three major ways of doing the same. First one is to strike off those companies which are not working. So simply get the companies striked off from the register of company. That is one approach, which can be done to certain class of companies we will discuss. Then there may be certain companies which can be liquidated voluntarily and the assets can be distributed among the shareholders or stakeholders of the company. So that can be the second approach. And the third approach is amalgamation. So amalgamation means merger of all those companies. There may be a need for composite scheme where there may be certain business or entity or assets which should be transferred to another separate entity within the group. So that would depend on the planning and need of the business. So first we will discuss what is the striking off of a company. So there are under company law, there is a provision that in certain cases, registrar of company can strike off a company. These are basically compulsory striking off, or where ROC takes an action and eliminates the company or make the company out of the system. So that where there is where a company hasn't commenced its business within a year of incorporation, and it has not been kept as dormant company as per the new law, then ROC can strike the company off. Then where the company has not been pursuing any business activity for preceding 2 financial year, and it has not sought the status of dormant company as per the company law, then there may be a situation where a subscriber to the memorandum have failed to fulfill their obligation of paying the subscription amount within 180 days of the incorporation of the company, or if the company is not carrying any business operation as revealed from the physical verification. So if the company has already vanished or not functional, non-available, then in such cases, a registrar of company has power to strike the company off. But there is a provision that in some cases, person or company owner of the company can approach ROC and ask for striking off of the company. So we are talking about voluntary striking off of company. In such, this is possible only when there is no asset or liability left with the company. So if the company has already, let's say, a company was incorporated for certain purpose, it was functioning in the past, and later on all assets have been sold off or distributed to through any process or transferred to some another company, and the cash left is distributed or paid off to all the liabilities. There is no outstanding liability left. In such cases, if the shareholder passes a special resolution and apply to ROC, the registrar can strike the company off after giving due notice to public at large. Certain companies cannot be struck off by ROC, that is specifically mentioned. So any of the listed company cannot be struck off by the registrar of company. Then Section 8 company, which is not-for-profit entities, cannot be struck off by registrar of companies. Then any company which have pending charges for satisfaction, means they have taken loan in past, or the loan is still outstanding and the charge has not been cancelled, or then that company cannot be struck off. Then if there are prosecution or compounding application pending, such companies cannot be struck off. Any vanishing company which need prosecution, then that company cannot approach for striking off. Company delisted due to non-compliance with listing agreement. So in such cases, obligation is there for the promoters to fulfill, to give exit opportunity to the public shareholders, and hence such companies cannot be staggered off by the company. If the company have inspection, investigation pending, or any action or prosecution is pending as per under company law, such company cannot be stacked off. Then if the company has taken public deposit and is in default of repayment of such deposit, then such companies cannot be stacked off. Similarly, inspection investigation under the company law is also one of the reason where companies cannot be stacked off. If there are, let's say, we have found in some cases there were several companies within the group which were not functional and no assets have left in the company. Assets have been transferred, so nothing is left. In such cases, we approached and we have successfully got many of the company stacked off by ROC in a simplified manner. So here the no regulatory process is there, but simple. First, the board meeting need to be there, so board would approve, take note of that there is no asset or liability left. Then the same matter goes to the shareholders of the company, and shareholder passes a special resolution, and post that approval, the application is made to ROC for giving a strike off to the company. And then based on the process, the registrar of company processes the application, and then the company is striked off. Another option is voluntary liquidation. So now we know that voluntary liquidation process was earlier under the company law. Now it has been shifted to the insolvency and bankruptcy law, since it is part of the bankruptcy and insolvency and bankruptcy code. So here the process, any company which have been formed for a specific purpose and the purpose is fulfilled, or where the article provides for entity shall be liquidated on happening of certain event and that event has happened, or where management of the company decides to that there is no operation, nothing to be done. In such cases, company can be taken for voluntary liquidation, and voluntary liquidation process is prescribed in detail under the IBC. So in such cases, there are two preconditions. One, the company is not being liquidated to defraud any person, and the company has no debt or it has debt which can be fully paid. So that means a company should be solvent company. If the company is solvent company, then that can be voluntarily liquidated. Process of voluntary liquidation would be basically there will be a board meeting where board would consider declaration of solvency and submit it to the registrar of company, stating that company has sufficient assets to repay all the liabilities which may arise. Then the matter would be placed before the shareholders of the company, and shareholder passes a special resolution. And post that, then they will also appoint a liquidator, which will be a insolvency resolution professional. And then the matter would be placed before creditors for their approval. So if the creditors are there, then their approval with 2/3 majority is also required. Post that, the management of the company is transferred to the insolvency professional, who makes a public announcement, newspaper announcement asking for claims, if any, which will be consolidated by him, and based on the claims, he will determine the person who are entitled to the assets, if any, left. So the claimants of the assets of the company, and then he would carry the valuation of assets if there are any, and try to liquidate each of the assets and put the money into a voluntary liquidation separate account, and post all assets are liquidated and converted into cash. The cash can be distributed to the claimants, which will be shareholders, first the creditors, then there will be creditors, shareholders. And after all these things, he may apply to a registrar of in National Company Law Tribunal for the dissolution of the company. So typically the process, the National Company Law Tribunal would give notice to registrar of company and official liquidator and take their view, and post considering their view, it will dissolve the company if they think that all the liability has been duly paid off, and there is no business is left, nothing need to be done. So this is a process which takes around 6 months to 1 year in case there is no major litigation or any outstanding tax demand, etc., is left. In some cases here, the liquidator, because it is a voluntary process, liquidator may be asked to distribute the assets in pieces. So let's say one company is only holding shares of another company, and the shareholders of the company are individuals. Then, and there is no third party claim left, so the liquidator may distribute the shares or investments in the ratio of the shareholding, and it will be sufficient compliance of the law. So these are the two methods through which individually each one of the company can be taken, considered, and closed, liquidated, or resolved. But now we are talking about a scheme of arrangement. So a scheme of arrangement is one of the most enabling provision in the company law, where all kind of a scheme of arrangements can be made, which might involve merger, amalgamation, or even a demerger within the same scheme, and it can be very complex also in some cases. So this method is one of the easiest and simplest way to consider for group restructuring, group consolidation, and leaning out of the group. We will discuss this in more detail, with including their legal aspects involved in this, and what all compliances need to be done. So whenever we are thinking of merger amalgamation, there may be different laws which would be applicable. So applicable laws may be, in case there is a listed company, obviously certain additional law is there, but for all companies, company law is the main governing law. Then there will be income tax, which is applicable to all companies. Accounting standard provisions are there. Then stamp duty law is there. Then industry specific regulator may be there. Then in some certain cases, Reserve Bank of India or FEMA law might attract if there are foreign shareholders are involved. Then if there is a big group, competition law might also get attracted. And where there is a listed company, then is involved in any of the cases, then SEBI regulations and master circular comes into the picture. So we have to take care of all those laws while making the plan, besides all strategic aspects and planning aspects relating to simplification and issues. So if we think of the process, how this is approached. So first is the planning part, obviously. So planning starts with the basic understanding about all the companies, what are the issues which might get attracted. So we have to take a detailed diagnostic view of the group. What all companies are involved, what is their present structure, what kind of business they are doing, where the registered office of those companies are there, then what the assets, what kind of assets are there, whether there is immovable property, whether shareholding, whether jewelry or any other assets or any manufacturing facility, real estate, etc. So all those things need to be studied in detail. Then we have to determine which companies are redundant or dormant or underperforming or non-performing, and which companies are actually working, and whether those companies which are working can be consolidated, whether this will enhance the value for the shareholders and business, for the business, whether there is assets which are charged with some bank, whether the bank's NOC would be simplified or not. So all those things, detailed study is done. First approach is that. Simultaneously, the valuation exercise need to be done in detail, so that there is wherever there is a merger, there will be some equity swap ratio, because consideration would be in the form of equity in most of the cases. After that, after considering all these, the matters would be placed before the board of directors of each of the companies. So if, let's say, if 20 companies are involved in the structuring, the scheme, the structure, the valuation need to be placed before each of the company's board, and they should independently consider the scheme and the valuation report and the swap ratio, what consideration the company's shareholders are getting, and based on that, they will take a decision to approve or not to approve the scheme. So that will be the second important aspect. Post that, there will be NCLT process, where the approval would start. So first is the filing of first motion application with the NCLT, asking for exemption from meeting of certain class, like shareholders meeting. If there are 9 shareholders who have given their no objection in the form of affidavit, invariably on receiving 90% or more consent, the NCLT gives exemption from the meeting, but there is no specific law with respect to the same. However, with respect to each class of creditor, there is a specific provision that if there is a consent of at least 90% in terms of value of any class of creditor, then the meeting of such class of creditor may be exempted by the NCLT. So considering that application, NCLT would direct either the exemption from meetings or holding of certain meetings under the supervision of court-appointed chairperson, alternate chairperson, and scrutinizer. So on the direction of the NCLT, there will be meeting of shareholders on each class of creditors for various companies on specific dates, unless there is a specific exemption by NCLT. The meeting can happen in the normal course, like uh, any other shareholders meeting or any other creditors meeting. In the meeting of creditors and shareholders, there will be a specific approval process, which is in the meeting, whoever is present, the simple majority of those persons who are present in the meeting, and in value term, at least 3/4 of the persons who are casting their vote should be positive in favor of the scheme, then the scheme would be considered to be approved. This applies to both in case of shareholders meeting or in case of creditors meeting, if there is a meeting, if there is a physical meeting. So post that, obviously there will be a post meeting. If the meeting is successful for all the companies and scheme is approved by all the entities involved in the scheme, then the scheme would be filed with there will be application to for final approval of the scheme by the NCLT for implementing the scheme. So that would be basically considered to be the second motion application. In case of second motion application, the company law tribunal issues notice to various regulators, which includes registrar of company, official liquidator, regional director of MCA, income tax authorities. Besides that, there may be various other regulators, like in case of listed company, the stock exchanges and SEBI. Then in case of NBFCs, RBI may be the regulator. In case of big size companies, if applicable, CCI or Competition Commission of India may be given the notice. So this notice is very important, and based on that, no objection of these authorities are necessary. So post that, if the certain date is fixed for the final hearing, where objection or no objection of all such regulatory authorities is presented and discussed by the applicant company's lawyer and NCLT bench and the representative of the regional director, MCA, official liquidator, which are the lawyers of them, they represent the case, and if they all give their no objection, then the scheme is approved by the NCLT. Post that, there will be a filing of order. So certified true copy of the order of the tribunal would be filed with a registrar of companies, which will make the scheme effective. Sorry. Post that, the real consolidation process would start. So transfer of assets, transfer of liabilities, filing of various returns files like income tax, consolidation of income tax claims, if there is any. Then there may be transfer of immovable properties if there are any. Then corporate action for transfer of share or allotment of new shares, etc. would happen to make the scheme complete. A few important aspect is there. The approval of shareholders and creditor in the meeting would be through dual majority. So all the shareholders or creditors, as the case may be, should give their consent in the meeting by 3/4 in value and simple majority in number. So that is very critical. We have to understand that in case if the meeting is happening through postal ballot or e-voting, the same principle would apply with respect to the approval. Then any scheme which is being presented before NCLT can be objected by any class of shareholders who are holding, any group of shareholder or individual who is holding at least 10% of shares of any of the company. So let's say the scheme has 20 companies involved, out of which all other are in quite good control of the group who is filing the scheme. However, there may be one or two companies which have third party shareholders which are not in control or not in good term with the existing promoters or management of the company, and they want to object to the scheme, then they can approach NCLT and put their views before the NCLT, and NCLT has to consider their view if they are holding at least 10% of the shares of any of the group company, any of the companies involved. Similarly, any creditor, whether it is secured creditor, unsecured creditor, operational creditor, if it is having an outstanding debt of 5% of the total debt relating to any of the applicant company, he or she or it can approach NCLT seeking asking for objection to the scheme. They don't want to allow this scheme to go through. So involvement of any of the company which have any disgruntled creditor could create a total roadblock for the entire group restructuring. So we have to plan this very minutely beforehand before approaching to regulators, because the whole exercise can get futile if such happens. Then there is a specific provision relating to dispensation of meeting. I have already discussed. If there is a consent of at least 90% of each class of creditor, any class of creditor, in the form of affidavit, then the meeting of such class of creditor is not required. Similarly, in some cases, shareholders meetings are also dispensed with if 90% more than 90% of the shareholders have given their no objection to the scheme. There is no specific legal backing to such exemption, but this is invariably given by NCLT benches, considering the fact only 10% or more of the shareholders can object to the scheme. So if 90% or more are giving, more than 90% are giving their consent, then there is no one left to object to the scheme, and hence a scheme can be approved, and hence there is no need for meeting. Then was one of the most important aspect is income tax, because everyone is concerned what tax liability, what cost would be involved in such kind of restructuring or consolidation plan. So one of the most important aspect is the income tax, and income tax specifically defines amalgamation under section 2(1)(b). If the definition of amalgamation, which is given under this section, is getting fulfilled in the scheme of amalgamation as proposed under company law, then the scheme is considered to be an scheme of amalgamation under the income tax. So here it simply says merger of two or more of the companies with another company, or merger of two or more companies to form a new one company, would be considered to be an amalgamation, where all the assets and liabilities of such amalgamating companies are being transferred to the amalgamated company. Shareholder holding not less than 3/4 in value of the shares of the amalgamating company become the shareholders of the amalgamated company, or otherwise result in acquisition of property of one company by another company pursuant to the purchase of such property by another company, result in such property of another company after the winding up. So all such schemes are considered to be a scheme of amalgamation. If that definition is getting fulfilled, then there is a specific exemption from capital gain liability under section 47. So 47 clearly says that wherever there is an amalgamation, then the transfer of the capital asset from the amalgamating company to amalgamated company would not attract any capital gain. Then the transfer of by the shareholder in the scheme of the capital asset being the share of another company, if the shares is made in consideration of allotment, in consideration of that transfer, he or she is getting shares of another company, and here the amalgamating company is Indian company. So wherever there is Indian company is the transferee company or amalgamated company, and is issuing shares to the shareholders of a transferred company in consideration of scheme of amalgamation, then they will be fully exempt. The shares which are getting received by the shareholders free of cost, or in exchange of the shares, would not attract any capital gain liability at that moment. So it is just a pass-through provision. It is not giving any specific exemption. The law says that this event is not considered to be transferred. So wherever the resultant entity would transfer the asset, or the resultant shareholders sell their share, they will attract the capital gain considering their actual cost of acquisition of the original shares or asset, as the case may be. Where, there is a specific provision relating to transfer of accumulated losses and unabsorbed depreciation. So this provision is also made for making such companies to be amalgamated where there is a loss, carry forward of loss. So if there are provision of carry forward losses, and that can continue to be in the hands of the amalgamated company in case the conditionalities given are getting fulfilled. So it is applicable to all industrial companies and certain other class of infrastructure companies. Though the conditions are the amalgamated company has been engaged in the business in which accumulated losses or unabsorbed depreciation remain unabsorbed for 3 or more years, and has been continuously on the date of amalgamation at least 3/4 of the book value of the fixed assets held by the it 2 years prior to the date of amalgamation. These are the conditionality with respect to amalgamating company. Now, with respect to amalgamated company to take the advantage of accumulated losses and unabsorbed depreciation, so they should hold continuously for a minimum period of 5 years from the date of amalgamation at least 3/4 of the book value of the fixed assets of the amalgamating company which they have acquired as part of the scheme, and continues with the business of amalgamating company for a minimum period of 5 years from the date of amalgamation, and fulfill such other condition as may prescribe. So obviously, these are the major condition under the income tax. If these conditions are getting fulfilled, then amalgamation, the unabsorbed depreciation and accumulated losses can also be taken over by the transferee company or the amalgamated company, as may be called. Then comes important aspect is accounting standard. So one of the accounting standard, there are two major accounting treatment given under the law. We are talking about Ind AS 103, which is applicable to all big companies or listed companies. So here there are two methods. Same is also available under AS 14, which is applicable to those companies which are not following Ind AS. So in both the cases, the law is simple: pooling of interest method and purchase. There are two methods prescribed. 103 Ind AS 103 clearly says that all companies which are under the common control should follow pooling of interest method, where all the assets and liabilities are transferred at their carrying value, and all assets, liability, including reserves, are transferred in the books by line consolidation. But the other method is if there are non-controlled entities involved. In such cases, purchase method would be applicable, where all assets and liability are acquired at their fair value, and reserves are left over. The difference is obviously transferred to the capital reserve as the or goodwill, as the case may be. Where a listed company is involved, before going to the NCLT, the company need to approach stock exchanges where the company is listed under Regulation 37 of SEBI LODR regulation, and there is a detailed guidelines provided under SEBI Master Circular. Recently, last Master Circular came in June 2023, so that need to be complied with. This approval of stock exchange or SEBI is required even prior to filing of application to the NCLT. So unless the approval of NCLT is in hand, no such application can be made. It is also to be noted that in case of listed company where the merger is being done or amalgamation is being done of only the wholly owned subsidiaries of the listed company, then no approval of stock exchange or SEBI is required. the company has to file the scheme with before BSC or NSC, as the case may be, for public information purpose only, and post that they can directly approach NCLT and get the approval done as may be required. So that becomes a bit simplified. Then another important aspect is the stamp duty law. So uh, because it has the largest cost component in any scheme of amalgamation or merger, wherever there is a scheme, it is well settled provision that the order of amalgamation or merger or scheme, any scheme as approved by NCLT or earlier by High Court, is considered to be an instrument chargeable to duty under stamp law, which is well settled by Supreme Court in many of the cases like HLL, or in case of Litaka, which are landmark judgment in this regard. So it is well settled position that it is dutiable instrument, and duty need to be paid. Now, what percentage the duty would be applicable would depend upon the law of the state. So because the stamp duty on capital asset is under uh, state jurisdiction in most of the cases, specifically where immovable properties are involved. So there are many states which have prescribed a specific rate of duty, stamp duty, on scheme of amalgamation, like in case of Maharashtra, Karnataka, Kerala, Gujarat, Rajasthan, even Uttar Pradesh. All such states have a specific rate of duty, and that is applicable. Like in case of Haryana, the rate of duty is 1.5% of the fair value of immovable property involved in the scheme falling in that state, or 1.5% of the value of consideration being paid as part of the scheme, whichever is higher. If there is no immovable property, obviously there is nil duty prescribed in the state of Haryana. However, in such cases where there is no specific rate of duty, then general rate of duty, which is applicable to conveyance deeds, would be applicable. So through this conveyance deed, that is the scheme of order of NCLT, assets are getting transferred which are immovable properties, then general the rate is 6% of the fair value of the property. Or in case of no immovable properties involved, then 2% plus 1% registration charges would be applicable. So that is also a provision. So we have to consider this as one of the costs involved, and while making the plan for scheme of arrangement. Now, considering what are the benefits and challenges, obviously we have discussed various benefits, but we can reiterate those benefits. So it will help in economizing the scale of operations. If there are multiple companies within the group carrying similar kind of business, they can be consolidated to make a bigger size company of the same industry. Then there will be simplified compliance, so there is very less chance of missing out any compliance, and we all know that the cost of non-compliance is very high. It improves financial clarity, that it helps to know who is controlling, how much percentage is controlled, and whenever there is a fund which need to be placed to some certain specific business, if all such businesses are under one roof, it is easier to transfer. Right now, it is very difficult to even give loan from holding company to subsidiary, or subsidiary to another peer group subsidiary sister concerns. So it might require charging of interest on such loans, which also involves deduction of TDS, etc. So all those cash burden is there. So it is easier to have simplified structure and clarity. Then it also enhances value, because consolidated entity becomes bigger and simpler. So clarity in valuation is easier. So value enhancement would happen. There may be consolidation of many assets which are redundant for one company but can be useful for another. Promoters holding would get streamlined. promoter may get direct control on operating companies. So if there is a distribution of dividend by the company, it can directly come in the hands of the promoter, individual promoters, though obviously there will be tax implication, but that will be one time. But in case there is a layering, there is multi-layer, then there may be cascading effect of the tax. So first company is giving dividend to another, another is giving again to another, and finally it is coming to the promoters. So every time there may be a tax leakage, because now there is no DDT, and tax is payable by the individual entities or persons who are getting the dividend. Scalability and growth, it also helps in simplified structure, always helps in growth and scalability. So if the company is planning to raise fund in the form of private equity or going for public, it is simply necessary to have simple structure, no conflict within the group, single entity carrying single one kind of business. So there are various benefits which we have already discussed. Sir has also given a very detailed discussion on such aspects. Now we have to see a few challenges which comes. So if we are consolidating everything, obviously it will be easier to manage the company, but there may be certain businesses or certain things which cannot be consolidated. Like there are certain licenses which is not easily transferable. Regulatory hurdles are there. So those companies cannot be consolidated, should be kept out. Then there may be high stamp duty liability in case of a certain immovable property getting transferred from one entity. So one entity to another. So that can be considered as one of the difficulty. Then there may be jurisdictional complexities, like the companies which are involved are having registered office in multiple states, different states. So NCLT of different benches would get involved and it will be complicated. Another one option is to shift the registered office of all the companies at one place, which is most viable in terms of stamp duty liability, etc., and then approach for the merger amalgamation. Then there may be intercompany transactions. There may be certain transactions, certain things which are placed, which are mortgaged with the bank, which requires cleaning up before going for approaching the NCLT or filing of application to NCLT or seeking of creditors NOC may be challenged in some cases. So that complexity would be there. Then in longer run, there may be a need for further division of the businesses or succession planning. So in such cases, if we are consolidating everything in one place, it might be challenging at a later date when next generation would come and they want certain location-wise distribution of assets or businesses, or maybe vertical-wise distribution of assets and division. So in such cases, it is necessary to have long-term view, and based on that decide which entities or which companies or which businesses to be kept separate. So in such cases, maybe all non-functional company or all holding company may be consolidated, and then business-wise distribution can happen as part of the same scheme or in another scheme. So that kind of planning can be done. There has been hundreds of leaning out cases of listed, unlisted companies involved. A few cases I am just discussing here to give a view. Like we have got involved in some cases, like in case of Jubilant Industry and Jubilant Agri Product. It is simple. There were two companies which are one Jubilant Industry is a listed company, and its subsidiary company is a working company which has the main business but not a listed company. Then the holding was also held by different entities, which are three different entities. So as part of the same scheme, all the companies got merged, all the holding companies, shareholding companies were merged into the listed company, and as part of the same scheme, the listed company is merged into the unlisted subsidiary company, and now the unlisted subsidiary company is getting listed as part of the scheme. So this is a whole process which will simplify the structure. The shareholding of the listed company would have direct operations businesses, which major business which was there with the Jubilant Agri and Consumer Product company, and the shareholding of that listed company would be held directly by the family trusts. So this would simplify the structure and help to eliminate the non-functional layer of holding companies. So this is done and it is almost complete at the verge of completion. Then we have seen many other cases like in Metropolis Group, they have merged various companies, group companies to make single entity, which is a listed entity. Then Accenture is also one case where private company has consolidated various companies which have been created over a period of time. Recently, also many of the companies have filed such cases for consolidation. In past also, TVS Holding and Sundaram Clayton has consolidated all the company. Also, as part of the scheme, it was demerged. So it is a TVS family distribution through the scheme. Recently also we have seen DLF has filed a scheme involving 16 companies getting merged, all are subsidiary, wholly owned subsidiary of the company. Then Gujarat Gas Limited has consolidated many companies within the group. Then India Bulls Enterprises has filed 1.5 year back a scheme involving several companies which were there to simplify the structure. Oberoi Realty has done similar thing. Sequence Scientific is one of the leading veterinary medicine company and which has acquired a Vyush group companies, 7-8 entities involving different business verticals, research labs. So they are now getting consolidated into one Sequent Scientific, which is a listed company. So in listed space, we are easily getting the information in the public domain. But in case of unlisted domain, also this kind of things are happening. In many of the cases, even in listed companies, promoter, where the promoter holding are scattered in many of the companies, are getting consolidated to make the structure simple, make the control clean. And we have seen we are involved in many of the companies which are planning to go for IPO over a period of 1 or 2 years, are approaching us to simplify the structure, to consolidate all non-functional company, to eliminate those companies which can be stacked off easily, or of which assets can be distributed through voluntarily liquidated, and rest of the company may be consolidated to take advantage of their inherent values, like maybe in some cases the authorized capitals of all such companies are consolidated at one place. The fund can be consolidated to make a larger capital base of the holding company. So such kind of schemes are very prevalent, and we are helping in many of the groups which are closely held. It also helps to simplify the structure, to help succession planning. Like in many of the cases, the entities are collapsed and shares are getting transferred into family trusts. Sometimes one or more than one family trust for long-term succession planning. So all such things are happening. So that's why, considering our experience of many people approaching us for such thing, we have created a product which is called Leaning Out, where we go deep into the group's structure, analyze the group, and suggest the right strategy for consolidation and simplification. We advise on all aspects like company law, SEBI law, income tax, GST, RBI applications, accounting treatment, stamp duty law, and all practical issues. Then we help in valuation of entities. We determine what is the right value or what swap ratio should be there, suitable to all. And then the scheme and all legal documentation, approval from various regulatory authorities, and post-transaction implementation support like accounting disclosure, compliances, etc. So we do all the hand holding, and that has helped in to many group to simplify their structure. And as sir was saying, Pawan sir has always promoted and advocated such simplification for better governance, better value unlocking of the groups. Thank you. I think we will do more in the question answer session. I think I've tried to summarize.
Thank you, Manoj. Thank you very much for giving very elaborative presentation. And you have covered all aspects which I was expecting. Okay. Now, yeah. So this is a very interesting topic, no doubt, but simultaneously it's a very complicated topic also.
Yes.
It looks like that when we say it is very easy, but when we go in detail, it is really tough. Okay.
Yeah.
Anuj, before I'm taking the questions of a participant which I have received now and I have received yesterday, I just want to ask, what is your methodology to do this? How you, though you have in the last slides you have mentioned, but for the benefit of the users, can you just tell then that how I should approach to you, how you will do this work, how you will create value for me for this restructuring, whether this value, uh, this restructuring or consolidation is only just for the compliance purpose or it creates some value also or some. So what is your methodology you follow?
So, sir, this is not the simplification is not not only for cost reduction or simplification of compliances. It has many reasons, and we have to understand the reason first. So we do a discussion with the promoters or the family if it is family owned, or if and the professional involved in those groups. So we do a detailed study of shareholding structure, and we have seen that many of the cases there are certain redundant companies, but they might be holding certain share in a listed company. Like in one cases where listed company have 28 companies, out of which 14 are directly holding share in a listed company, and rest are holding across each other among themselves. So entirely it becomes a 31 companies mess. And if we try to understand who is the owner of that company, is very difficult to know. So the promoter who is actual owner or promoter is holding 3-4% only in the listed entity, and rest all 60-65% shares are held through this mess. So we have to understand which all companies are non-performing, redundant, or dormant. What is the relationship among themselves? So inter-se shareholding, money transfer, what kind of loan and advances given, etc. So all those things is mapped very deeply, and then we decide what actions to be taken. So in many of some cases, we may decide that, okay, these companies might be simply striked off through ROC process. The rest of the companies, we do single scheme of amalgamation or multiple scheme of amalgamation. There may be a need to have one company as a group holdco, like which is called the CIC, core investment company for the family, so that they can continue to invest within the group and without seeking approval from RBI as an NBFC. Or maybe they need one company through which they can invest their surplus fund in outside the company, so the NBFC license can be retained. But multiple NBFC licenses is not necessary. It has a lot of burden, compliance burden, and regulatory issues. So all NBFCs may be merged into one entity, NBFC, and out of that NBFC also, core businesses, core investments may be hived off to another company post amalgamation of all the companies.
Okay.
And then all the company which is holding shares post amalgamation maybe collapsed into the listed company to take the holding of the promoter directly in his personal hand. So that kind of planning can be done. So deep analysis is required. Financial study, impact of all aspect, like what will be the stamp duty cost, whether there will be any leakage of cash, whether there is any regulatory hurdle, any creditors hurdle in any company, there is in third party involved which kind of object to the scheme, and to make so all such companies are separated, and all companies which are simple and easier to approach can be approached in one go. Then the process of valuation starts, formal process of legal documentation starts, and then the process of merger amalgamation, as the case may be, starts. So planning takes sometimes even to 1 year in some cases, because it requires involvement of first the professionals of the group, and then the promoters, their understanding, their need, understand their long-term goal, etc. And then based on that, certain companies are left out and certain companies are made part of the scheme.
Okay. So Manoj, now I have some questions.
Okay.
Our family-owned unlisted public limited company has cross-holding in an LLP, a foreign wholly owned subsidiary, and a step-down subsidiary. All shareholders and director belong to the same family with no external member. The family heads effectively control all operation, while the others merely follow a direction. The entity frequent engage in intercompany loan and transaction, particularly before export activity. What are the discrepancies or mismanagement occur? These practices could lead to legal complication.
Discrepancy, it is difficult to tell the discrepancy here, but yes, this kind of thing is always complicated, so need simplification and understanding of the case, what need to be done, what is the right control structure, who is actually controlling, should be in paper also controlling the share of the company. So that can be done through simplification of the group and eliminating the cross holding, etc.
Okay. What is the main difference in strike off and liquidation?
So a strike off is the process where ROC take an action and strike the name of the company from the register of companies as they maintain for all the companies. So that process is simplified and does not involve much compliances from the point of view of the company and its shareholder. No shareholder would gain anything, no creator would get anything post, because the precondition is that there is no assets or liability left in the company.
Okay.
But in case of voluntary liquidation, there will be distribution of assets and liability as per the waterfall mechanism provided under IBC law. So all the creditors would be paid first, secured first, then unsecured, then whatever is left to be given to the preference shareholders, and then whatever is left that would be given to the equity shareholders.
Whether the case of Tata Capital Limited merger with Tata Motors Finance falls in this category, what would be the fate of the unsecured creditors, including unsecured non-convertible debenture holders?
Tata Capital merger with Tata Motor Finance. Yes, it is, but the purpose was different here. They were mainly planning to consolidate the two NBFC businesses at one place. So that was the main intent. However, obviously it has simplified. Regulator also want only who all professionals know that RBI has made it mandatory that in one group there cannot be more than one entity carrying similar kind of NBFC business. So that similarly, all regulators are also asking, like SEBI is saying, all in one group there should not be more than one broker or more than one merchant banker. So such simplification is one part of this leaning out. However, the leaning out of two companies, merger of two companies may or may not be considered to be leaning out, because it is not so difficult or complicated structure. With respect to unsecured creditor, I think for all scheme, it is very much clear that the liability does not extinguish. All liability goes to the transferee company. So no risk for any unsecured creditor as such.
Whether trust stamp duty be levied in case of merger with holding of subsidiary company having land in UP?
Yes. Duty is payable. Only in case of wholly owned subsidiary, there is a specific exemption of 1948. There is an old circular of 1948 which allows transfer of immovable property from one holding company or holding company and subsidiary company, where the holding company is holding more than 90% of the shares of the subsidiary company. That circular is obviously complicated. Similar circular was there in Delhi of 1937, which was withdrawn. However, there was second circular, and based on that, recently the High Court has upheld that this exemption is still available. So similar view can be taken for UP also, and in case of wholly owned subsidiary or holding or subsidiary with 90% holding, the exemption can be claimed.
Whether can you Manoj just explain about the more on the?
Yeah, so in case of like I was discussing, there is a recent judgment where it is clearly said that the circular of 1937, which allows transfer of immovable property from holding company to subsidiary or vice versa, in case the holding company is holding 90% or more share in the subsidiary without paying the stamp duty. So that circular is giving exemption, and that is for transfer of assets. So transfer of immovable property, including transfer through a scheme of merger amalgamation. So this 1947-48 circular of UP would be available in normal circumstances, unless it has been withdrawn. It is being withdrawn by the state government. So there will be no duty. Otherwise, there will be duty, stamp duty liability. So all scheme is subject to stamp duty. We have to get the stamp duty adjudicated. Whether it will be zero or not, that would depend on circumstances, the state, and the adjudicating authority of stamp. So we have to go deep and then give the opinion. We cannot give a random opinion based on simple facts. I think a few more questions are there, I think,
No,
on.
no, just a minute.
Sorry, yeah, sure.
I was mute and I was just talking.
Okay.
In few cases of wholly owned subsidiary holding company merger, we have seen that meeting of shareholders and creditor were dispensed with the NCLT even when no written consent was obtained. Can this place in all the similar cases?
Yes, we have also got in many of the cases such kind of exemption. So yes, in case of amalgam merger of holding company and wholly owned company into holding company, stock NCLT benches are giving exemption. It is based on various judgments where it is clearly said it is old precedent of listed companies, many listed company involving such cases in high courts. Various high courts have given such kind of exemptions, considering the fact that all assets and liabilities are already owned by the holding company, and hence there is no transfer as such. So basis this, they are not asking for meeting of holding company, either the shareholders or the creditors. However, the subsidiaries meetings are called and their view is taken because subsidiary companies' creditors would be now the creditor of the holding company. So we have done in many cases, like in case of Mankind Pharma or Lumax Auto and many other, and APL Apollo, we have done similar kind of cases.
Okay. Manoj, what are the key aspects which need to be considered in case of valuation for a scheme of restructuring?
So valuation is now done through as per the Companies Act section 247 by registered valuer. So registered valuer is directed to do detailed diligence, and based on that they will decide what all method and approaches can be applied for valuation. So fair valuation need to be determined in case of all scheme of amalgamation, other than in case of wholly owned subsidiary where there is no need for any issuance of new share. In all such cases, valuation is done, and valuation need to be fair valuation. So approach can be DCF, discounted cash flow, maybe net asset value, where assets are taken to their fair value in case non-operating companies. It may also apply, the valuer may also apply comparable company valuation approach or comparable transaction approach. So many various approaches are there, and it is the prerogative of the registered valuer to take the opinion, reasoned opinion, and they have to give the justification in their valuation report which approach they have applied, which if more than one approach is applied, what weight is given in specific cases. Like in case the merger of unlisted company with listed company, for listed company they have to consider the market value also, market approach and income approach and maybe asset approach. For unlisted company, they cannot apply the market value, so they may apply comparable companies multiple approach also. So this the opinion of the registered value is very important here, and they have to justify in reasoned manner in their opinion.
Okay, Manoj, can you just say value in the consolidation? What is the role of valuer?
So valuer's role is very important because what kind of shares or consideration to be discharged by the transferee company is determined by the valuer. So valuer has to carry the relative valuation of all the companies involved and then decide what consideration need to be paid. The consideration is discharged in the form of equity share of the transferee company generally. So the what should be the right value of the transferee company should be taken. It is even in case of listed company, it cannot be simply the last traded price. It will be based on various parameters, and it is not a standalone valuation, it is a relative valuation. So relative valuation approaches are there, and they apply multiple approach and give their different weights to different approaches, and based on that swap ratio is decided. Based on that the consideration is determined, and that consideration is the key for consolidation.
Okay. Our registered office of all the companies are situated in Delhi, but factory or other functional unit in Haryana. So we have to pay stamp duty in Delhi as well as Haryana.
Yes. For immovable property situated in Haryana, you have to pay duty there. Post order is registered with registrar of company Delhi. You have to approach the tehsildar there and get the scheme adjudicated and stamp duty to be paid. As per the law, 1.5% of the fair value of immovable property situated in Haryana need to be paid there. And obviously in Delhi, because there is no immovable property involved, there will be 3% duty in terms of the Delhi Tar judgment.
Okay. In case of consolidation of group companies, if as on the record date 4 to 5% shareholder of the group company are not traceable, then how can we give them consolidation in our flagship company?
And that is a challenge. You have to, those shares which are to be given may be kept in abeyance. And if you are issuing, let's say, dividend in future and remain there for 7 years, then the shares, including unpaid dividend, would be transferred to IEPF as per the law, company law. But till that time, it will remain there. You cannot avoid that.
Okay. Can we claim benefit of Section 72A during consolidation of group companies in all cases?
No, it is available to certain class of companies only. So that includes manufacturing companies. So industrial undertaking is one of the condition. Besides that, infrastructure company or public sector companies are exempt, can take the advantage of 72A.
Okay.
Subject to condition fulfillment of conditionality, which is
Whether
carrying
if,
out business of 5 years, etc.
whether a promoter of whether a promoter who is ineligible under 29A of Insolvency and Bankruptcy Code can make an application for compromise arrangement under Section 230 of Companies Act?
Yes, that provisions are applicable only for being resolution applicant. Okay, and so they cannot take the company back through insolvency except in case of SME companies, MSME company. But for a scheme of arrangement or compromise arrangement, all kind of companies, all kind of promoter can approach. There is no restriction as such.
Okay. In our application of merger, the same is pending because of IT department objection. Can mere loss of revenue of group company be ground for objection to a scheme of the IT department?
No, I think though in many cases income tax department make objections to such schemes where there is huge tax benefit, but simple tax benefit which is already provided into the law cannot be a ground for them to object to the scheme. However, if there is a avoidance or a scheme which is meant for avoiding the tax or can be objected, and if it is against the interest of the public, NCLT can reject the scheme. In case your case is solid, you can approach NCLT and the scheme can be approved.
If the undertaking involves an asset which is purchased by the company 3 years ago, what will be the nature of capital gains at the time sale of such undertaking?
I think you are talking about slump sale or transfer of undertaking
Yes.
in simple
Yes.
cases. So, in case of business assets, apparently it is based on the block of asset. So we have to do the valuation, determine the capital gain based on the block of asset value method, and whatever the capital gain is arising out of that, that need to be paid.
Okay. Kindly clarify on the treatment of reserve under the scheme of obligation in case of common management.
So in case of common management, if the company is not a listed company or not following Ind AS, then AS 14 simply says you have to consolidate all the assets and liability at their assets liability, including reserves, at their carrying value. And the difference between the assets liability and value plus the consideration should be considered to be adjusted in the reserves of the company. So it will be adjusted in the capital general reserve of the company. However, in case of companies following Ind AS, if the assets are higher, liability is less, then it will be considered to be capital reserve. In case liability is higher and assets are less, assets are higher, liability is higher, means you are issuing larger consideration, then the difference would be considered to be a goodwill.
Okay. We have one wholly owned subsidiary in Mauritius and two step-down subsidiary in Mauritius through the wholly owned subsidiary. The
Okay.
accounts of wholly owned subsidiary do not include the consolidation of SDS, step-down subsidiary. As a result, the Indian parent company does not go beyond consolidation, the wholly owned subsidiary. How the loss of SDS will eventually impact the entire structure. The parent company continue to remit fund to Mauritius, and his capital erosion will ultimately affect the parent company. The auditor have merely noted the non-consolidation of SDS in the financial statement for the last 4 years. Is the legally compliant?
Consolidation, yes, as per the law, consolidation of all the entities step down subsidiary need to be done. So if it is not being done, it is wrong.
Okay. Okay. Manoj, now when I was reading this question, so question itself is a complicated.
Yes.
You can understand, I was saying the
Yeah.
investor, the regulator, everybody, when they see whether you are legally compliant, when the structure is complicated, they think that you have done this because of some hanky-panky.
Yes.
Okay.
Whenever there is a complicated or maze of structure, regulator always becomes suspicious. So it is always easier to explain when it is simple.
Okay. Whether a company against which a liquidation order has been passed under IBC can go to for merger.
IBC liquidation, yes, one opportunity, last opportunity given under liquidation law also, I think within 45 days from the date of order of liquidation, company can have option to approach for scheme of amalgamation under 230.
Okay. We have common shareholding in our company and the partnership firm. Can we merge both?
Partnership firm, yes. If it is a joint stock company, it can be considered to be a joint stock company, then partnership can be merged into company. But LLPs cannot.
Explain something more on the partnership companies merger, how it is taking place, because they say always confused.
So there are partnership firms which are considered to be a joint stock company. If that definition under company law is getting fulfilled, then it can be considered to be a joint stock company and can be then NCLT would have the jurisdiction to consider the scheme of amalgamation of such partnerships. That is provided under the law itself. It has happened in many cases in the company law, old company law also.
Body corporate,
That is called joint stock company under Chapter 9 of Old Company Act.
what is the main issue relating to employees and employed contract to consider in corporate restructuring?
Generally, the scheme clearly scheme need to be said to be neutral for all the employees of the transferor company. So they should get the benefit of all the continuity of employment, their track record, their number of year of existence, employment should continue. That is the provision, and it is provided in most of the schemes. And if it is not provided, generally the regional director MCA object to such schemes. So generally, all employees of the transferor company automatically becomes the employee of the transferee company post amalgamation, and they will have the same year of experience there, and their remuneration should not be deteriorated. So let's say the gratuity benefit for would continue if they have worked for 4 years in older company and 1 year here. So 5 year would get completed there.
We want to merge our three group companies wherein the shareholders are common. Do we need to get the valuation done?
Yes, in all cases where other than wholly owned subsidiary, valuation is mandatory
If
because
the
companies
company
need to.
cannot provide the futuristic projection, can we ignore the discounted value method for the valuation under amalgamation?
Yes, but logical justification should be there. In case there is a track record of business and probability of continuation of business for a longer period, then it is always advisable to have the cash flow statement, future cash flow statement, and do the DCF for closely held companies. But if it is just an investment or just a physical asset like immovable property holding company, then DCF may be redundant. So proper justification in the valuation report is required there.
Whether auditor certificate for compliance of accounting standard is also required for an unlisted company.
Yes. In all cases, it is required from the statute order of the company.
How the company will determine the record date if it is not defined in the scheme?
Record date on record date is relevant only where there is some movement of shares, frequent movement of shares, like in case of listed companies. Otherwise, there is no need for record date. You can take the list of shareholder of closely held company as on the effectiveness of the scheme, and that would be the ground for distribution of consideration by the transferee company.
How the can we change the name of the surviving company to the name of the company being dissolved?
Yes, that is possible, subject to basic compliances of ROC. The scheme would be considered to be a single window clearance for approval of shareholders and other persons as may be required. So no specific approval is required, and ROC allows switching of the name of the transfer company to the transferee company.
Okay. Can treasury share be issued in lieu of shareholding of holding company and subsidiary company?
No, is the Companies Act 2013 clearly.
Earlier it was.
Earlier, it was allowed. Cross-holding are kept in trust and are considered to be treasury stock. And there are many companies where they are still carrying. But the new Companies Act clearly says that no treasury stock can be created as part of the scheme.
Okay. Manoj, next is our is a group company being proposed to merge with the main company. Is there any relaxation on timeline for such merger, or some process is to be followed as applicable in case of unrelated company?
No, there is no such relationship among the shareholder is not a condition for getting any exemption. Only in case of holding company and wholly owned subsidiary, this can be done. There is also a provision of fast track merger under section 233. If the conditionality of such of 233 is available, then you can approach regional director MCA in place of NCLT, and that would be a fast track process. So here there are two class of companies which are eligible. One is holding company and wholly owned subsidiary, and where you can seek the approval of 90% of shareholders and creditors. Then you can approach. And other one is all small companies. So all small company means company which is having a asset base of net worth of 4 crore or turnover of 40 crores. If that is getting fulfilled, then you can be considered to be small company, and then you can approach in the fast track mode under section 233. Sir, you are mute.
Sorry. Our is a group company being proposed to merge with the main company. Is there any relaxation on timeline for such merger, or some process to be followed as applicable in case of unrelated company?
I think there is no difference. I think you have asked this question earlier also.
Okay. So Manoj, all questions I have asked, which we have received,
Yeah.
and which are there on the system just now. I'm just asking you as a layman, when I'm planning to, the question is, today's topic is leaning out,
Yeah.
consolidation. So in the consolidation, what is the biggest problem? Like I, as a owner, I'm discussing with you that I have a company. Then suddenly, my entire plan is haywire because you are suggesting me something. I'm talking about the first monetary term. The second is compliance term. So what are the first issue? Because in my opinion, stamp duty, that
Yes.
is one cost, which is there. When you say you merge this and do this, then stamp duty issue comes.
Yes.
So is it its biggest hindrance in the financial term because it's outflow?
Yes, in financial term, it is one of the biggest cost, and one of the means other than professional cost, it is the cost basically, because generally all the schemes are tax neutral. So no capital gain, no GST leakage are there, but stamp duty applicability is there. So it is the in terms of the cost, yes. Other than that, there may be complication that there may be certain shareholders or creditor who might not give exemption to approval to the scheme. So that can be a big challenge. Then there may be certain regulatory issues in some companies which cannot be consolidated. So we want to keep that company away. So
Okay.
such considerations are
So
there.
this is financial. Any other? So financial two, stamp duty and the professional fees. What is other cost?
No other cost. All other are, I think, saving of cost only.
Okay, now.
Long-term saving of cost.
Okay.
Yes.
So when you are calculating, when you are convincing your client, so you must be calculating that this is the total cost and this is a saving. So are you giving this metrics to them?
Yes, broader saving can be given, but piecemeal saving, certain savings are basically notional kind of things, like time of the key managerial persons, time in managing the affairs of that company, or handling certain litigation, tax litigation, compliance aspects, etc. So they are not, they cannot be measured in monetary term, but broader sense, all such schemes would help to reduce 30-35% of the cost of easily.
Okay, and what is the main hurdle for compliance point of view, other than the monetary?
There is regulated entities like NBFCs are involved, then regulators approval may be a big challenge, because we have seen in many cases that some companies are registered NBFC, but there are many companies which might be triggering the obligation to get registered and has not been registered in past. So whenever we are filing such scheme with RBI, they will scrutinize the entire group, and if they found certain violations, then it becomes a challenge. So such kind of actions can be a challenge in some cases. In some cases, some third-party shareholders who are disgruntled, having, let's say, 15-20% stake in one of the company, could be a showstopper for entire exercise. And they are not getting convinced. So they single person can stop the whole scheme.
The rest of the thing, there's no issue now.
Yeah, yes.
Okay. So Manoj, if I can conclude, and the time is also approaching, you mean to say the leaning out is good for cost saving,
Yes.
improved governance, enhanced valuation, strategic agility, and regulatory compliances. Am I
Yes.
right?
Yes, perfectly.
Then you have mentioned that if you are doing this work, then see 360-degree work is required in this, which is
Right.
diagnostic review. Okay, what is the structure, how this company
Yes.
connected, which company. Then you have to make a strategic planning, whether you want to consolidate, demerge, disinvest, closure, or voluntary winding up. It's okay.
Right.
And how the maximum advantage and impact you can take. Then
Yes.
you will see legal and regulatory support. Okay, like merger, amalgamation, binding up process, filings, MCA, SEBI, GST, other authorities. Okay, income tax, and then compliance of tax law, FEMA law, any other law. Am I right?
Yes.
And tax and financial advisory you do, that the system should be tax efficient, which include the stamp duty also, and minimum financial liability and tax neutral scheme you want to create.
Yeah.
And you have to do the valuation support also, which you are doing.
Yes.
Then you do implementation execution. After doing this, then you will do implementation, that scheme you have to file, do this, shareholders approval, and other thing you will take, all intercorporate loan liability communication with the stakeholders, that you will do. And
Right.
that after receiving order, you do post restructuring monitoring. Okay, that how to do this, because now as per law, Companies Act, you have to give in report of the year that the entire merger process things has completed. Am I right?
Yes.
So this 360-degree, you can do the work.
Right.
You have in-house facility or you take outside help?
Yes. So generally all the component involved in this kind of a scheme is in-house. We are doing 360-degree. We are doing the planning, diagnostic view and planning, then valuation, formation of a scheme, legal representation before various regulatory authorities, and tax, accounting advice, etc. We are doing in-house. However, in certain cases, we need to have stamp duty adjudication in various remote areas. So there we need with third-party support. So that we will take certainly if the company is not able to do themselves. That adjudication is post facto process.
So as a promoter, if I'm coming to you, then I will get it. My cost, you will say, my valuation will increase. You will make simplicity, and I will be more risk compliant.
Right.
Right. Okay. So thank you very much, Manoj. Thank you very much for giving in detail the entire thing, and thanks that you can handle and work the entire consolidated things. So
Yeah.
thank you for the very lively and discussion.
Thank you, sir.
Friend, thanks all my participant, those who have participated. It's a very technical subject, and it's required a specific audience who want to understand this concept.
Right.
But it's a good concept. This is a good thing. Everybody should follow in the group, and it will be a win-win and useful for all. So, friends, we are stopping here, and now, as I told you, that our journey is continue, and today this was the 204th webinar. We have done. Now, our next webinar will be held on the 14th January or 24th January on nitty-gritty, which will be on the environmental footprint and P6 disclosure and BRSR. Okay, so this called principle B6, which is environmental footprint and B6, because now ESG is very, very popular, and ESG concept is becoming now attracting point for every corporate. Earlier governance was there, and now ESG is there. So we will follow this. Thank you very much. Good night.
Thank you, sir. Thank you. Thank you, everyone. Thank you.
मनोज
बोल दो मेरे को।
हाँ देखो ना मनोज